Hello, my name is Amber Rouse Holloway, and you are now listening to the July 2022 episode of My PIP Monthly. Today we will, of course, discuss a case law update. First up is the case of Macosta v. Metro Group Property and Casualty Insurance Company. This is a soon-to-be published opinion. Then we have Hope Network Rehab Services v. MCCA. This is unpublished, issue June 9, 2022. And lastly, for our case law update, we have the case of Michigan Head and Spine Institute v. Mid-Century Insurance Company. And then as to trending topics in PIP litigation, we will talk about the recent reversal of Griffin v. Trumbull Insurance Company, which is a published opinion, and an instance where a lower priority insurer can be held responsible for payment of PIP benefits despite the existence of a higher priority insurer. All right, first up, the case of Macosta Century Medical Center v. Metro Group Property and Casualty Insurance Company. Ultimately, this case eliminated the defense of res judicata and collateral estoppel when an assignment of benefits occurred before a judgment or order was entered, because there was no privity between the assigner and assignee. Just by way of background, the plaintiffs here were two medical providers who provided treatment to an injured party after an accident. Here, the injured party's girlfriend's grandmother insured the car through a Metropolitan Group no-fault insurance policy, and the injured party's girlfriend was an included driver on that policy, but the injured party himself was not specifically named on the policy. So after the accident, he treated with these medical providers and assigned away his rights to the no-fault benefits before August 2017. He then filed his own lawsuit against Metropolitan Group and State Farm Benefits relating to, State Farm Insurance Company relating to PIP benefits. As the injured party's lawsuit was pending, this was in Wayne County, plaintiff, the medical providers, filed suit in Kent County Circuit Court to recover the assigned benefits or the medical portion of the claim. In the Wayne County suit, the defendants filed a motion for summary disposition, arguing that plaintiff was not entitled to no-fault benefits because he violated MCL 500-3113B, which required him as the co-owner of the vehicle to maintain insurance coverage, which he did not do here. The defendants then filed that same motion in the Kent County Circuit Court case. The Wayne County Court case granted the motion before the Kent County Circuit Court case could consider the same motion. But after the Wayne County judgment was entered granting summary disposition, both defendants in the Kent County Circuit Court case filed an additional motion for summary disposition, arguing that plaintiff's claims were now barred by collateral estoppel and res judicata, basically indicating that, or arguing that the prior decision granting dismissal of the Wayne County Circuit Court case controlled the still pending Kent County Circuit Court case. The Kent County Circuit Court granted summary disposition, holding that plaintiff's claims were now barred by res judicata and collateral estoppel. On appeal, the Supreme Court reversed and held that the judgment entered after the assignment did not bind the assignees, the providers, because the assignees were not in privity with the assignor, the injured party, with respect to that specific judgment. Therefore, res judicata and collateral estoppel did not apply. Now, the court did indicate that defendants may still raise the first lawsuit's winning arguments or issues, underlying defenses. They may still raise them in the second lawsuit, but is not necessarily controlling on the second lawsuit. It's important to note that the claims here arose before tort reform was enacted with respect to the order of priority, and it was solely decided on when an assignment of benefits was executed. It did not mention or address the medical provider's new statutory standing under the 2019 no-fault reforms. Moving on to the case of Hope Network Rehab Services v. MCCA. Here, The court determined that a medical provider failed to sufficiently plead the elements of tortious interference against the MCCA. By way of background, Hope, the medical provider, provided treatment to a Farm Bureau insured stemming from a January 2018 accident. Despite months of negotiation, Hope and Farm Bureau, so the provider and the insurer, could not reach an agreement with respect to the claims for expenses incurred. Ultimately, Hope filed suit against Farm Bureau seeking payment of the benefits, and during litigation, Hope amended its complaint to add a claim of tortious interference of a business relationship or expectancy against the MCCA. Here, Hope claimed that it had a business relationship or expectancy of a business relationship, that Farm Bureau would pay no-fault benefits for reasonable and necessary expenses. Hope alleged that the MCCA intentionally interfered with that relationship by refusing to approve payment or by threatening to withhold reimbursement to Farm Bureau. As a result of that, Hope said that they suffered damages, including but not limited to the cost of prosecuting the instant matter. The MCCA moved for summary disposition. On appeal, the court noted that to succeed upon a claim of tortious interference with a business relationship, the plaintiffs must first establish 1. The existence of a valid business relationship or expectancy. 2. Defendant's knowledge of that relationship or expectancy. 3. An intentional interference in inducing or causing a breach of termination of the relationship or expectancy. And 4. Resulting in damages. The Court of Appeals held that Hope failed to properly plead the third and fourth elements, but did satisfy the first and second one. Ultimately, the court held that with respect to the third element, the MCCA's conduct was not wrongful per se, and that Hope needed to demonstrate specific affirmative facts of unlawful purpose or interference. Here, they did not demonstrate any specific facts, such as illegal or unethical or fraudulent conduct, and none of that was the case here. And with respect to the damages, the court noted that a party does not recover litigation costs and attorney's fees by claiming them as damages. And lastly, for our case law update, we have the case of Michigan Head and Spine Institute v. Mid-Century Insurance Company. This is also an unpublished opinion issued June 16th of 2022. This one is also dealing with an order of priority issue, as with, I believe, the last two as well. So here, the court ultimately indicated that, or held that, PIP benefits are mandated by the No Fault Act. As a result, entitlement to such benefits is governed by the statutory provisions of the No Fault Act and not a policy. So no policy language incurs, and the court kind of gave an example that the No Fault Act is the rule book, is the play-by-play book, and not the policy. But only in the context of benefits not required by statute. So the optional coverage, the UM or the UIM claim, may a policy expand coverages beyond those required by the No Fault Act. I did want to give a brief background into the facts of this case. So here, the injured party was unfortunately severely injured in a motor vehicle accident, but at the time of the accident, she did not own a vehicle or maintain a no-fault policy. She did not live with a relative, she was not married, and did not have a husband or resident relative with a policy either. So following the accident, she did receive medical care, and her provider subsequently sought payment of that, which is why the suit was filed here. The payment was denied, and the providers filed suit. They named Mid-Century Insurance Company as the insurer of the owner of the vehicle occupied by the injured party as a defendant. They also named the USAA Casualty Insurance Company, who was the insurer of the injured party's father, who she did not reside with. And then they named the MAIPF, who assigned this claim to Citizens Insurance Company. So thus Citizens was also a defendant. So we have the Mid-Century Insurance Company, the USAA, and Citizens as defendant. In the trial court, Mid-Century moved for summary disposition, arguing that it was not within the order of priority. And here, the order of priority is obviously governed by NCL 500-3114, Section 1, which indicates that a person must look to their own policy, a spouse's policy, or a policy of a resident relative. As I stated earlier, there was no such policy existed for the injured party, and therefore Mid-Century argued that plaintiff, the provider, and the injured party must seek payment from citizens through the assigned claims plan. In response to the motion, plaintiff and the injured party instead looked to the policy language of the Mid-Century insurance policy. They argued that a specific provision of the policy extended PIP coverage to anyone who suffered bodily injury while occupying a covered automobile. The trial court did deny Mid-Century's motion based upon that, and the Court of Appeals reversed, arguing that because PIP benefits are maintained by the No-Fault Act, entitlement to such benefits is governed by the No-Fault Act and not the insurance policy. Again, they did note that with optional coverage, a policy can control that type of optional coverage, but any coverage that is mandated by the No-Fault Act must be controlled by the No-Fault Act. And moving on to trending topics in PIP litigation, I wanted to discuss the opinion of Griffin v. Trumbull Insurance Company. In this case, Trumbull, it is important to note that Trumbull was represented by Secret Wardle at all stages of litigation, so throughout litigation and throughout the appeals process as well. But ultimately, the takeaway from this case is that a lower priority carrier may be held and can be held responsible for payment of PIP benefits despite the existence of a higher priority carrier. Ultimately, and this took place earlier this month, the Supreme Court reversed the Griffin finding and held that a lower priority insurer could be held responsible even if there is a higher priority insurer that has been identified. This was reversed and remanded to the trial court for further proceedings. But I did want to give a background on this one as well. Just like in the prior unpublished opinion, we talked about the order of priority. Here we have the MCL 500-3114, and then MCL 500-3145 Section 1, which is commonly referred to as the one-year back rule. So these two general principles, statutes, guided the Supreme Court's decision in this case. Griffin, the plaintiff, was a motorcyclist who was injured in May 2016 when a truck merged into his lane and he crashed while attempting to avoid the truck. Plaintiff, Mr. Griffin, did retain counsel fairly quickly within 5 days of the accident. His counsel sent a letter to the truck driver whose name, address, residential address, telephone number were all included on the police report. The letter advised that plaintiff intended to take legal action but did not ask the truck driver to contact plaintiff or his attorney. Plaintiff submitted the claim to his the insurer of plaintiff's motor vehicle, Trumbull, which, like I said previously, was represented at all stages by Secret Wardle. Trumbull did not pay and made several attempts to contact the truck driver to see if the truck driver was insured or if there was a higher priority insurer. After retaining a company that also unsuccessfully attempted to identify the truck driver's insurance, plaintiff sued Trumbull for PIP benefits and named the MACP as a defendant, requesting that the MACP assign the claim. After plaintiff filed suit and more than 1 year after the plaintiff's injury, Trumbull hired an investigator who served the truck driver with a subpoena. The truck driver did appear for his deposition, wherein he revealed that he was working for a former employer at the time of the accident. And with that information, the parties learned that the insurer of the truck driver at the time of the accident was Harleysville. Therefore, under the version of MCL 3114 that was in effect at the time, Harleysville was a higher priority insurer as the insurer of the truck's owner. And this is the case because plaintiff was a motorcyclist. Both Trumbull and the MACP then moved for summary disposition. Trumbull on the grounds that Harleysville was a higher priority insurer, and the MACP asserted that it was entitled to summary disposition because plaintiff was insured by Trumbull at the time of the accident. The trial court did grant the motion for summary disposition as to Trumbull, finding that Harleysville could have been identified within 1 year after the accident, and if plaintiff had acted with reasonable diligence, they would have done so. As to the MACP, the trial court granted summary disposition on the grounds that there was no dispute between insurers and Harleysville was identifiable as the highest priority insurer. Now, moving fast forward to September 24, 2022, the Court of Appeals affirmed in a split as to Trumbull and the dismissal of the MACP in a published opinion decision. The Court of Appeals majority held that because the higher priority insurer was identifiable, Trumbull was not liable. And here, to reason with that conclusion, they cited the case of Fireson v. West American Insurance Company, which held that when a higher priority insurer cannot be identified, the general rule applies, and the injured party must look to his own insurer for personal protection insurance benefits. But because here Harleysville was identified and identifiable, that general rule did not apply. Then, in the Supreme Court, in a 4-3 decision split along ideological lines, the Supreme Court held that under the facts of this case, Trumbull can be held liable to pay Griffin's claim for PIP benefits because plaintiff exercised due diligence by doing everything the law required of him. The Supreme Court refused to reward Trumbull for its gamesmanship. The majority reasoning boiled down to one, that plaintiff timely made a claim against Trumbull, and Trumbull was first in the order of priority under the facts known at that time. And two, Trumbull could have acted more diligently by either denying the claim earlier, investigating possible higher priority carriers pre-suit, or paying and going after the other carrier later. And three, that the lower court's ruling left plaintiff with no remedy because by the time the higher priority insurer was discovered, it was too late for plaintiff to pursue it. It's important to note that the decision here does seem to open the door to quasi-equitable arguments around the order of priority and even possibly the one-year back rule 3145. There are clues in this opinion that Griffin is meant to be limited to the fact-specific basis. So the facts in this matter only, and is not a general rule to apply to general cases that involves similar facts. But these specific facts seem to rest upon multiple preconditions, all of which needed to be present to explain the result that the court came to in this reversal of this case. But ultimately, the outcome here seemed to rest upon who had the burden of identifying the truck and finding out who insured that truck that was involved, obviously, in the accident with plaintiff where he tried to avoid it. So who had this burden? And here the Supreme Court shifted the burden from plaintiff to defendant Trumbull, and found that because plaintiff had acted diligently, Trumbull carried this burden and Trumbull had ample time to conduct the investigation. I also wanted to note that the recent reversal of this Griffin case did find that a lower priority insurer could be held responsible when the claimant exercised the due diligence by doing everything that the law required, and the lower priority insurer here, in the majority's view, did not adjust the claim diligently. And they also noted that they came to this reasoning because by the time all of this was determined, the result would have left the plaintiff without a remedy. And that is all I have for you guys today for the July 2022 episode of My PIP Monthly. Please feel free to contact me with any questions and or concerns, and I look forward to talking with you guys again next month.